Welcome to the Contractors Revenue Disruptor Podcast, where we teach you to win $1 million contracts. I'm Michael D. Young. What's going on, family? I'm excited today to have a special guest with me, Miss Laurore. She is an attorney here practicing in the state of Florida. She is not only an attorney, but she's also a financial planner and advisor. And I am excited that she's here to talk to us on how to protect our family's future, not only with trust, but how we do estate planning. Now, I know for most of us, we think that all we need is a will. And I want to encourage you, wherever you are in your life, whether you're young or whether you're old, make sure not only do you have a will in place, but you're going to set up other things in order to protect your family's assets and ensure that your children, that those that you desire your assets to be passed along to, actually are able to receive it. So we're going to have some dialogue in regards to those things, but listen up, go ahead and tune in right now on how to protect your family's future by protecting your assets and the things you need to also plan for your future. So thank you, Laurore, for joining us today.
Thank you for having me.
Yeah. So, I know we were discussing in the past, like the importance of estate planning, and you've been doing this for a while now. What are some things you've been seeing that are common, especially in Black and brown families? Some common mistakes that you've seen where we have not prepared for the future, where we have not actually done estate planning.
Yeah, so not having anything at all, right? So not having a will, something as simple as a will. And when somebody passes away, not doing their probate. So then they wait for maybe 10 years, 20 years down the line when they need something to do maybe for the house. And then now we have to do the probate maybe of 2 other people. Oh. So not being proactive, either not having a plan or not doing the things they're supposed to do when somebody does pass away.
Gotcha. So some people may be listening to this and not even know or understand what is probate, right? There's so many families that don't know what probate is. What does it look like? They may have an idea, okay, this is what happens when we don't have a will, but can you explain like what is probate and what's the process for probate?
Yeah, so probate is the legal process of the court essentially distributing your assets, right? Anyone that passes away, if anything's left in your name alone, so I mean the dead person, it has to go to probate. The court has to say, okay, now this person is dead, Jane Doe is dead. Who is the legal heirs to Jane Doe? Who is supposed to inherit from Jane Doe? And another misconception we have is that if I have a will, then I avoid probate. Not necessarily. You still go to probate. Now, instead of the court telling you who are your legal heirs, you're telling the court who you've chosen to benefit from you. So that's really the difference between having a will and not having a will. But the probate process is still going through that court for the judge to decide, okay, you had children, so they should inherit from you. Then here are the things that you should inherit and how to split it evenly. So in Florida, for example, that process can take from 8 months to 2 years to 3 years, depending on the county, depending on the judge. So it's a long process. It's a legal process of distributing your assets.
Okay, gotcha. So if I heard you correctly, and this was, or maybe alarming for those that's watching this, even if you have a will, you can still end up having to go through probate. Why is that?
Yeah, so the will is funny because the Italian term for the will actually means probate. It's like a whole dictionary definition, but a will does not avoid probate. It still goes to the court for the court to deem that the will is valid. So even if you have the will, you sign it, you notarize it, the judge have to determine that will is actually valid. Once that is done and it says, okay, the will is valid, then we go through the distribution process. So if you just have a will, most likely you'll still end up in probate court. Unless you have a will and, maybe you did other things to avoid probate as far as adding beneficiaries or maybe having a Lady Bird deed, you will still end up in probate.
Yeah. Yes, we're going to talk about
you
Lady
don't avoid
Bird
probate
deeds.
by just having a will. A will still goes to probate.
Wow. So if we go through probate or have to go through probate, are there specific costs? I know you told us about how long it takes, anywhere from 8 months to 24 months, but what are any costs associated with probate?
Yeah, so depending on the size of your estate, Florida law holds that, typically 3 to 5% of your estate. So meaning if you have a house, if you have a car, the attorney can charge up to 3 to 5% of your estate. Sometimes attorneys charge flat fee. So for a summary probate, meaning something that is small, not a big estate, that's less than $75,000.
Say that again.
So a summary probate. So anything that is less than $75,000, meaning
$75,000.
Okay. So meaning the person that passed away, all of their assets together was less than $75,000. That's a summary, meaning it's supposed to be shorter. That typically an attorney could probably charge $5,000 for.
$5,000 just for an asset that's less than $75,000.
Correct. And sometimes that doesn't include the court fees, right? So you have the court fees, you have all the different things, but
administrative fees and everything.
Exactly.
Else.
So that's typically the cost. And again, you would hope that it's less time, maybe 5 to 6 months, but not necessarily. It could be 6 months, 8 months to a year, because it depends on, do we have enough judges? Do we have, how quick is the clerk with the process? So it could take a while.
Okay. So let's back up a minute, because I love this case study in regards to if it's $75,000 or less, it's called a summary probate.
Summary administration.
Mm-hmm. Summary administration. And so then we recognize we would spend no less than $5,000 just to go through this process that may take months, right?
Correct.
So
some may cost less, but I don't see it less than $3,000. That's the least I've seen.
That's the least you would see. So that's a hope and a prayer that it's less than 5, and it's somewhere between 3 and 5. So here's the thing, because I can hear a lot of people say, well, if the asset's only $30,000 and I have to come up with this money, just to get, some money, forget it. I got to wait all this time. I have to spend this money that I really don't have, and it's going to take me almost a year to get this money back. Why should I even go after it? You have any thoughts or advice for those individuals?
Yeah. So, $30,000, that's still some money, right? So that money, if no one claims it, it goes to the state, right? The word is called, it's cheat to the state. So meaning the state gets it. There is like a fund of unclaimed property that is just sitting there because people either didn't know the person had it, or they just never got through the process of doing probate. So it just goes to the state. So imagine, your dad or your mom, whoever worked hard, and even it's $25,000. That's still enough. That's still a decent amount of money for some people. And you just had to say, forget it.
Right.
I'm just going to go ahead and just let it go to the state.
Right. And I'm assuming that the time limit with probate also may include any creditors that may come for any monies they're owed as well, I'm assuming. How does that work?
So there is a process while you're doing probate, whether it's a summary or a full administration, meaning that it's over $75,000. It's called a notice to creditors. And essentially what you do is put a notice in the newspaper and say, hey, Jane Doe has passed away. Any creditors that are known, come forward and, make your claim. We have 90 days for them to come forward. If after that 90 days they don't come forward, then they're forever barred. But that means anyone, right, whether it's a personal credit, whether it's a financial, credit card, they can come forward and say, Jane Doe owed me $9,000, pay up.
Okay.
And if the estate has that money, you have to go ahead and pay up unless you, settle with them for less.
Gotcha. Okay. So when we start getting into assets over $75,000, I think you mentioned normally the probate costs are between 3 and 5%, correct? Of whatever the total assets
of the estate. Mm-hmm.
So do you recommend people hire an attorney for this process, or can they do it by themselves? Well, I know you're a little biased because you're an attorney, but what do you recommend?
So for a lot of the states, the full administration actually requires an attorney. You can't just go ahead and do it yourself. Summary, typically they allow you to have like a do it yourself kind of checklist for you to do, because it's a process that requires guidance, especially as a full administration. It's not a 1-2 step, right? It requires a lot of things for you to make sure that it's done properly.
Can you give us some examples of those things?
Yeah. So for example, even it's something as making sure you're filing for exempt properties. Some properties are deemed exempt, meaning that,
Homestead exemption, is that what you're referring to?
Exact. Some of them, right? So that means the creditors can come towards that because it's exempt. It's considered that it's taken away out of that pool where creditors can come forward. So you have to know to make sure you file for that so that that house is protected, or the car. Because in statute, right, you have sometimes maybe one car allowed and also a house. So it has a list of certain things, and statute kind of controls that. Probate is a very statute driven process. So if you're not familiar with the statute and you're not familiar with what forms to go ahead and fill out and what steps that comes next, you're going to be stuck.
Wow. Okay. Nice. So what are some things we can do to avoid probate?
Yeah. The free things, I'll tell you that first, right? Because I know people like the free things you could do right now is having a beneficiary on an account, an adult beneficiary. Like, I don't recommend naming a child as a beneficiary on any financial accounts. But if you know for sure who you want your, bank account to go to, name that person as beneficiary.
And they would name them where? On the will?
On the account itself. So
on
you
the
go
actual account.
You go to Chase. Most of them even allow you to go online. You say add a beneficiary, full name, date of birth. Sometimes they require social, sometimes not. And you go ahead and submit that. End of day. You pass away, the person literally has to go to the bank. Most likely they already noticed that, notify that you're passed away. Mm-hmm. They'll just submit their ID, show proof of that you've passed away, get the funds.
Man, I did not know that.
Easy,
so
easy
hold on.
Peasy.
So naming them as a beneficiary versus adding them to the account is two different things.
Correct.
Sounds like.
Yeah. If you add them to the account, they have rights to the account right away. That means you add me to your account, I join, I can go and
get that money.
We share the account. It's our money now. It's our money. But if it's a beneficiary, they don't have any rights until you pass away. And you don't even have to tell them that they're beneficiaries, really.
Man.
Until you pass away. Then they can have rights to the property. So it's the easiest way to avoid probate, right? I used to be a personal banker, and that's what I used to do, right? Somebody passed away, and they come, if they're a listed beneficiary, we verify their ID, do our own process, open up an account, transfer the funds.
Wow. So you all ought to say, thank you, Laurore. Thank you, because she just gave you all free game on how to protect your family's future. So,
well, let me add, make sure it's an adult beneficiary. Please, 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 because we have the misconception, people do it, that they add a child as beneficiary. If you add even let's say, okay, they're not a toddler. Let's say, oh, I'm going to add my teenager, 16 years old. Legally, they're still not an adult. So if you pass away and you have a 16-year-old that's inheriting some funds, now they have to be assigned a guardian. So you still now have to end up in a court, be assigned a guardian to go ahead and guard those funds for your child. So if you have a minor child, you should never name as a beneficiary to your account.
Nice. So any other free tips? Because we like free.
I like free.
Any other free? But that was a major one. Yeah, that was a major one.
That's the most easiest way to avoid probate, and you'll be surprised how many people don't have beneficiaries on their accounts, or it's not up to date.
Okay.
Whether the beneficiary passed away, or the most recent case, we have a probate that we're doing. Ex-wife is left on the account, and current wife wants the account. It's like that's a contract between the bank and that person, so they're gonna honor that. Doesn't matter what the will says. So ex-wife gets it. Sorry to you. You know, you could try and talk to her. I mean, if I was the ex-wife, I'm not giving anything back.
Right.
But you could try and have that conversation. But when you do that beneficiary contract, that is a contract between you and the bank.
Okay.
So upon your passing, they're going to honor that contract. Whoever you listed as beneficiary is going to be that person. So even though we want to add beneficiaries, we want to make sure we also update them. You got a divorce, somebody passed away, you change your mind, it pissed you off.
Right.
Whatever the case may be, making sure you update them accordingly.
Okay. What's up, everybody? If you are a construction contractor and you're looking to win $1 million contracts, grow and scale your business, I help contractors win $1 million contracts so they can make more money working fewer projects with less employees. And we do this through my mentorship program. In my mentorship program, we have bi-monthly group coaching, we have CEO groups, we provide you an online course, and we teach you the strategies you need in order to scale your business, and we help implement the systems you need on the back end to support your growth. Because number one, you definitely need the resume, the resources, and the relationships to scale your business. Then we've recently added a mentor protege program with major corporations. This is huge because number one, it allows you to learn how other major corporations desire their projects to be run, so you understand their expectations. You're learning, growing, and developing relationships with major corporations, which always leads to more business opportunities. I want to tell you, no one else is doing this in the industry, and you've come to the right place if you are looking to truly grow and scale your business. I've done it over and over again. I've won multiple awards for scaling a construction company, and I want to show you everything that I did to do it. So if you're looking to scale, grow your business, win $1 million contracts, sign up right now for my free training. It's very simple. It'll be on the screen, and we'll see you soon. God bless. Perfect. So last question with this piece is, let's say I've been named a beneficiary, but I'm not aware. Does the bank notify the beneficiary, or how does that communication actually happen if you're not aware?
It depends on the bank. Some banks would notify the beneficiary if, for example, you have the name of the beneficiary, address, and all of those things. Some banks will go ahead and do so. Some will not. So it really depends on the bank. I've seen where smaller banks will kind of take that initiative and say, okay, you are the beneficiary of this account because they have your information. And some banks, it's kind of like, you have to reach out and call their legal team or their, estate planning team and figure out if you are a beneficiary or if even there's a beneficiary name.
So I think to this point is the importance of families. And I know in our community, we have, I don't know, like an issue being transparent with the assets we either do or don't have, right?
Yeah.
So we have a real big issue. Like mama, grandmama will not tell you how much money they do or don't have. And so I think it's important that we work on that, whatever that issue is. Like, I don't know if it's a trust issue or we just don't want anybody in our business issue, whatever it is. I think
probably a little bit of both.
Yeah, we have to work on that because now whoever is our beneficiary may miss out because we don't know when we're going to leave this earth, right? Yeah. And I think that's the challenge, is that we don't know what's going to happen in this life. You may not be in a position where you can say, hey, it's there for you. So what is a way we can communicate that maybe in writing? Are there additional steps outside of the will that we take the next steps in estate planning?
If we'll kind of talk about that later. If you have a trust, right, you'll go ahead and kind of list things, or we'll have like a whole binder to list where things are. But something as simple as keeping things together, right? When grandma dies or when mom dies, we're not going around trying to find, this statement or that statement. Just have a list to say where things are. And I think the misconception is that, if you tell someone you're their beneficiary, you have to tell them how much is in the account. I don't have to tell you that. It's like, hey, I have a little something. If something happens to me, just know you're a beneficiary of that. That's all.
That's it.
Right? So at least they're aware that, okay, there's an account at Chase and I'm the beneficiary for it.
Right.
So that if you pass away, they're not trying to call Bank of America or Wells Fargo, trying to figure out where was grandma's account. Right. But you already told them.
That's
good. And again, keeping those things together, right? Having a binder and having kind of like a central location where everything is.
In a fireproof safe, hopefully.
No? So that is the biggest misconception. So we have people that have either in a safe deposit box or a safe, right?
Okay.
So if in a safe deposit box, something happens to you, you pass away.
You can't get to it.
Right?
Blow that sucker up.
We still now have to go to probate to have somebody assigned as your PR just to go into the safe deposit box.
Right. I
had a client, quick story, they had a safe, their fingerprint was the opening.
Oh my goodness. What's the point of that?
Well, they passed away.
Right.
Am I going to cut your hand and bring it home and open it?
Right.
So, now you have to get a drill to go ahead and drill it. So I tell clients, keep it safe, but not too safe where someone can't access it. Because when you're no longer here, we have to find out those documents.
Okay. Because we have, this is my personal business, but we have a fireproof safe, even though the keys are accessible. Okay. I think, so that's okay?
That's okay. As long as the keys are accessible and people know where the key is, right? The trusted individuals know it's like, that's where the key is. Okay. You don't want to leave things and then Like, where is it?
Jordan, you know where the key is? We got to show you where the key is, Jordan. All right. So that's great information. So when you mentioned a trust, so a lot of us here trust this, trust that, you know, some people think they can do their own trust. What's the truth about trust? And what is it?
That's a whole, you know, thing on its own. But a trust is a legal document, right? It is an extensive legal document that tells, you know, how you want things to happen. But it can be used while you're alive, right? If you're incapacitated, and also upon your death. So it's not one document you're going to use at, you know, at your death. You can use it throughout your whole life. If, God forbid, you're in a situation where you're incapacitated, and also at your death. There are a lot of misconceptions about trust because there are people, you know, unfortunately, because we're in a era where people are trying to get knowledge and learn about things, people are also taking advantage of that. They're trying to go ahead and sell trust and sell things. And it's like, you shouldn't trust that, right? Because a trust document should be drafted by an attorney. Okay. In Florida, actually, it is illegal for a non-attorney to draft a trust.
Say that. Hold on. Let's say that one more time. Say that one more time. You said in Florida?
In Florida, it is illegal for a non-attorney to draft a trust. It is considered an unauthorized practice of law.
Wow.
Right? So, and people, you know, will argue with you. It's like, well, technically they're not, you know, giving legal advice, just giving a template. So, and the question is this: would you trust everything that you've worked for, all of your assets, everything, your legacy, with a $50 template that some guru online told you to go ahead and download?
Mm-hmm. So, okay, so let's
would you trust that?
Right. So let's stick with that for a second. So if let's say I did download that template and I use that to implement a trust, is it actually valid or no?
It depends.
It depends.
Because
what it depends on?
If on the language of the trust, how the trust is set up. I had a client that came to us and they set up an irrevocable trust. Somebody set up one for them. What they thought was an irrevocable trust, and it was completely set up incorrectly. It's not even a valid trust because they were and that's more into the detail of
the language,
how irrevocable trusts work. But they were both the grantor, the trustee, and the beneficiary of an irrevocable trust. Anyone that does trust law and that understands trust knows that cannot be the case for an irrevocable trust. So you get a template and they just tell you to plug things in. You plug things in.
And you don't know what to plug in.
You don't know
You're just plugging
in things, and you spit out this document, and it's like, it's not even valid. Forgetting the fact of even making sure you fund the trust and putting things in the name of the trust, but the document that you have in your hand, it's not even a valid document. So it's, you know, for the people that always say, well, I can't afford an attorney. How do you know? Have you tried to reach out to an attorney to see how much it costs? Or even if you cannot afford an attorney, have you tried to at least have an attorney review the documents on your behalf to see, okay, you know, what I have is actually a good document.
Right.
Because you don't want to wait till when you actually need it.
Right.
And then you tell you, actually, you can't use that.
Right. So in terms of cost, what are the typical or average, or let's back up. Where do we start as far as cost normally here? Let's say in the state of Florida, average low end normal starter price for a trust.
And it depends, right? It depends on the law firm. It depends on so many factors. If you're married, how much assets you have, are we transferring one deed, you know? So it depends on a lot of things. But I would say the average that I've seen will probably be $2,500 or so.
$2,500.
Thinking a single person, not many assets, and just straightforward, right? Okay. That's the ballpark. Okay. Something more complicated, right? An irrevocable trust, perhaps, that can definitely be more in the $5,000, $7,000, or even $10,000. Because a lot of things go to it. Are we married? Are we doing a joint trust? Or are we doing an individual trust for each, you know, spouse? So it depends on a lot of different factors. Yeah.
Okay. So you've talked about so far, it's important to have a will, because even if you have a will, you still will end up in probate, right? But now we're going to add a trust. So we have now a will and a trust, right? So if we have the trust now, do we avoid probate, or do we still end up in probate?
If you set up the trust properly and you fund the trust, the keyword funding the trust, making sure things are owned by the trust, then yes, we avoid probate. And when you do a trust and you do a will with it, the will is called a pour-over will. And essentially what it does is it's used as kind of like a catch-all. It's saying, hey, I have a trust. I'm going to make sure that everything is named in the name of the trust, or the trust is beneficiary to things. But just in case I forgot something, so that means we have to go to probate. But it tells the court, hey, I have a trust. Make sure everything pours over into that trust. Hence the name Pourover Will. So they come together because a Pourover Will, again, is kind of like a backup plan. Just in case life happened, you forgot to name, the trust as beneficiary to an account, or you have a property somewhere, you didn't have the trust be the owner or the remainder for it. So that's where the will comes in. So they kind of work together.
Okay.
Yeah.
Okay. So we've talked about will. We've talked about getting the trust. We talked about the cost of a trust. Now let's talk about, you talked about funding the trust. So I'm assuming we can fund the trust with all types of assets. That would be bank accounts, right? We can fund the trust with, I'm assuming, life insurance policies. We can fund the trust with real estate, stocks.
Yep. So the key thing, right, and I just addressed this recently in one of my videos, assets. And I don't want to make it seem that you need to be wealthy to have a trust, but you need to have something to put in the trust. There is a lot of misconception, people coming, like, let's set up a trust. And it's like, okay, what are you going to put in the trust? I have nothing. Then I'm doing you the service, just setting up a document, and you have nothing to fund the trust.
That's good.
It's just a piece of paper.
That's good.
The trust has to own something.
Right.
Right. So I'm not trying to deter people that have nothing to say, well, you don't need a trust because you don't have any assets, but we need something, whether it's a life insurance policy, a bank account, we need something for the trust to own, because if the trust is not owning anything, all I did was draft you a legal document, a piece of paper, and say, here, have a nice day.
Nice. What about business interests?
Yeah, that is 100%. The best thing you should do is to have a trust, have your business interests, because I don't know if you know, right? Your bank account right now, if you're the sole member of your business, if you pass away right now, it stops. Because no one else but Michael can go ahead and sign on that business account, right?
Correct.
So if you pass away and you don't have a trust set up and you don't have a successor trustee to step into your shoes to handle your business, that business have to stop, go to probate, because the business still has to go to probate, dissolve properly, and then you're able to distribute your assets, pay wherever you had to pay and everything else. So the trust is probably like the best tool for a business owner to be able to kind of plan for a succession plan for the business.
Wow, that was good. So we have a business and it's profitable, has assets. You said it will have to dissolve potentially. I'm assuming based on whatever the operating agreement states, bylaws or whatever, that determine how it will close its doors, right?
Yeah.
So let's say, for instance, there's no one else to run the business and the spouse is going to inherit everything per the will and trust. Does she still have to go through probate for the business, or will the trust actually be able to control what happens with the business as well?
It depends on your setup strategy. So if your operating agreement doesn't speak to the trust either being a member or the managing, controlling things, then yes, it has to go to probate.
That's
so
good.
What we typically do for our clients, we have, with everything with your estate planning, you have to plan properly. You have to strategize things based on your specific situation. That's why I always tell clients, never one size fit all. I can't tell, even with the prices, I can tell you like it's going to be $2,500 because it depends on, do you have businesses? Do we have things we have to plan for? So with the business, what I typically tell a client, if you have the trust be a managing member of the LLC, right? Meaning instead of, Michael Young, maybe Michael Young could still own 10%, but the trust 90%. Michael Young has now passed away. Well, the trust is an entity, right? It continues on. The trust can continue to, the business or dissolve it, and it avoids probate. But if Michael Young is the sole person, the sole member, and Michael Young has passed away, even though the wife is listed as the trustee, but the trust has no interest in the business legally, it doesn't own it, it's not a member, you still have to go to probate because the trust is just outside of that. It has no actual interest in the business.
Gotcha.
You have to tie them together. You have to make it work together so that something happens, the trust can step in.
Gotcha.
And that's where it goes back to that piece of paper. Just because you have that trust document, that piece of paper, but you didn't strategize properly, you didn't list it, in the place that it needs to be listed, it can't just step up and say, well, we have a trust, we're just going to go ahead and do things. It has to be set up properly. You have to go through that process and do that due diligence to make sure those things are, those stones are placed where they're supposed to be.
Awesome. That's great information. And I know we have some time constraints here, but I do want to touch on one last thing. How we fund the trust. Mm-hmm. I think that's also really, really important in thinking about, okay, what assets we're putting into it. But I know you are the finance attorney. And so we want everybody that's watching this to follow Laurore, reach out to her for assistance in setting up your will and trust, and also any funding that you need for your trust. So can you talk a little bit about maybe a few strategies or things you've been doing to assist your clients with actually funding their trust?
Yeah. So a lot of the clients, when we set up a trust, the initial thing is that, okay, we're going to put the property in the trust. That's easy.
Real estate,
right? We go through the process. We actually draft the deed because we have to change it from your own personal name into the trust. So we go through that process. But the other thing that we don't think about is like investment accounts, right? Mm-hmm. We can actually have the investment accounts be owned by the trust. You open up an account in the name of the trust. So let's say ABC Trust. Mm-hmm. You'd open up an account at Schwab or Fidelity, whichever, not Robinhood. We'll talk about that later. And actually have the trust be the owner of that investment account.
Okay.
And as you're, trading and investing in the market, the trust is growing. So that upon your passing, the trust already owns those assets. Nice. So, that's funding the trust. Because the misconception is that if we add the trust as beneficiary to an account, that's enough to fund it. It will avoid probate, but that's not really funding the trust. The trust has to own things in its own personal name because the trust is its own person, technically. It's ABC Trust or whatever you call the trust. It has to own things. So that's the funding part. We have to make sure that the trust is owning things, having things in its name and such.
So that's real estate. What about life insurance?
Mm-hmm. You could either buy the life insurance in the name of the trust, depending on the kind of trust you have, right? There's a list of different kinds of trusts, or have the trust be the beneficiary of the life insurance policy.
Gotcha. So is there a preference or is there a rule of thumb doing one versus the other? Because I would assume that for most policies, we would just name the trust as the beneficiary.
Yeah. So if you already have an existing policy, what you'll do is just name the trust as beneficiary. Some people would open up an irrevocable trust, meaning what cannot be amended. It has its own tax ID, and actually have that trust be the owner of the life insurance policy. So they actually buy the life insurance policy in the name of the trust. That's a little bit more different. It depends on your strategy and what you're trying to accomplish, but that's an option as well.
Okay. I think most people try to accomplish tax savings.
Yeah. And, some people, more recently, they're trying to be the Rockefellers and have,
Right.
And it's sometimes you have to bring people back to reality. And it's like the thought is nice, but reality of it is like you're not there, right? People want to go ahead and buy and get because they hear these things. I'm going to get a life insurance and be able to pay myself and everything else, right? Life insurance works is like as far as whole life or universal life, whichever you go with. The cash value is what you'll be able to borrow against,
right?
People think I'm going to go ahead and have $1 million cash value. Just thinking basic, for you to have $1 million cash in cash value, imagine how much that life insurance have to be.
And how much it has to build up.
Exactly, to have that cash value. So that's the misconception. They think, I'm just going to get a life insurance and build cash value and just borrow from it. And it's like, slow down. Yeah. Let's get to the basics first. And then we can see how we get, to that level. But, I like to remind clients, baby steps. We can get there. And it's not to say that we're not going to prepare for when we are getting there, right? So that we have things in place, but you have to be realistic and trying to start that baby step slowly but surely. Awesome.
I know, can you speak on, as we wrap up, ladybird deeds? Can you just talk about that? Because some people haven't heard that term before.
Yeah, it's actually one of my favorite tools in estate planning. So the legal name is an enhanced life estate deed. And what it does essentially is like adding a beneficiary to your home. We call it the remainder. So let's say you had a property and you have an adult person that you want to leave it to, but you still want to retain your rights, right? So you want to still be able to go ahead and sell the property if you wanted to without their permission. You want to be able to go ahead and take out a loan against the property without their permission. That's the beauty of the ladybird deed. You can go ahead and do all of that, You name them as remainder, as beneficiary. Upon your passing, they get the property without having to go to probate. But as you're alive, you retain that right, and it's revocable. So if at any point you're like, I don't care for this person, I don't want them to inherit the property,
you can always change it.
You can go ahead and revoke it and change it. And with Florida residents, you retain your homestead. So you don't lose your homestead exemption just by doing a Lady Bird deed. So it is the best way for people that maybe cannot afford a trust or may not need a trust, right? I'm a big advocate for a trust, but sometimes it may not be needed. Let's be clear about that. It's not that I wholeheartedly believe in trust, but sometimes we can find different tools to still avoid probate without having a trust.
Awesome.
And that's the truth of it, right? I'm not going to sell you something. I'm not a salesman to just say, here, I need a trust when you don't really need it.
You're not one of those attorneys.
No.
You're not just trying to get rich.
No, because it's like, sometimes you can find ways to still avoid probate and be cost effective with it. And a Lady Bird deed is the best way to do that, especially when it comes to real estate properties, where if you know who you want to live it to, an adult, right, an adult beneficiary, you can go ahead and name them and still retain all of your rights. It's like, they don't even have to know, honestly. Because they're not signing anything. Again, It's kind of like an account of the beneficiary. Right. You're adding them, you're listing them, you're the one signing for it, and they don't even have to know if you'll still want to tell them, but there's no requirement for them to sign or need to know that they are a remainder, what we call it, aka beneficiary of that property.
Awesome. So listen, everybody, Laurore has given us so many gems, and I know this is helping a lot of people, right? So if you could go ahead, share this with someone in your family that needs to hear about this. We have to stop being silent and at least, like she mentioned, just tell somebody that they are a beneficiary. Now, I'm not telling you how much was in there,
you don't
but
have
just
to.
know if something happens to me, it's there for you. So thank you, Laurore, for being here. I really appreciate your time. I know there are going to be hundreds of people probably knocking at your door, calling your phone, just because they need your help. So if you could just let the people know, how can they follow you on social media? I know you've been doing some webinars and some series of training on this topic. Yeah. So how can they learn more about estate planning and what you're teaching?
Yeah, so our firm is JP Law and Wealth Advisors. We're on all social media platforms at The Finance Attorney, so Finance Attorney. And our website is www.jplawandwealth.com. And we're pretty much on all social media platforms. What we do is educate our clients. We have educational topics, and we talk about the things that no one would talk about, even besides the trust. What happens if you're sick and end of life? Do you want someone to pull a plug or not? Those hard conversations. So that's what we love to do. We like to educate our community.
Awesome. Well, thank you again so much. I really appreciate your time here. All right, family, that's a wrap. So if you would go ahead, like and share this episode. We want you to continue to grow and learn and protect your family's future. See you soon. Thank you for joining us on today's episode. I'm so excited about your new journey. And if you are a construction contractor looking to win $1 million contracts, join me by going to www.winmilliondollarcontracts.com. See you soon.